Wonderful. Hello, everybody. Welcome to the Justice 101 program. It's brought to you by Eastern State Penitentiary Historic Site. And my name is Curry. My name is Curry Sautner. I'm the president and CEO of Eastern State. Eastern State is the world's first penitentiary, America's first penitentiary. We are located here in Philadelphia, and our work and our mission is around advancing public understanding of the criminal justice system and the impact that it has on the lives that are affected by it and creating a more just future. So today I'm going to host this amazing program on the Fourth Amendment and really looking at the Fourth Amendment in a time of digital technology, but also getting our framing correct. What is the purpose of the Fourth Amendment? How did we get here? How has it been tested over time? And then how is modern cases really exposing the Fourth Amendment to a new world and a new way of understanding? So we're doing this in commemoration for the Bill of Rights Day. So on December 15th, 1791, so this Sunday, it's Bill of Rights Day. So this is the day the final paperwork was done on the Bill of Rights. And there's some fascinating history around the Bill of Rights, but we're also highlighting that Fourth Amendment because of it. Today, we have brought you two fantastic experts that will really help expand all of our knowledge and understanding. And so let me introduce them right now. So Robert, welcome. Robert Fromer serves as a senior attorney with the Institute for Justice. Robert is the director of the Institute for Justice Project on the Fourth Amendment, which litigates to increase search and seizure protections for all Americans. Robert, it's wonderful to have you on the program. I know we've been talking about this for a while, and it's really great to have you on here. Okay,
really
next. Yes, we're going to dig in deep and see how much we can cover. Next, a good friend of mine, Clark Neely. Clark is the Senior Vice President of Legal Studies at the Cato Institute. His areas of interest include constitutional law, individual rights, overcriminalization, and coercive plea bargaining, as well as police accountability. Clark, it's fantastic to have you on the program as well.
Good to be here.
So let's dive into it. So it's Bill of Rights Day. I always feel like I hear Carol Birkin in my head, who we're going to send out a great book by Carol Birkin and Akhil Amar if you want to dive into the Bill of Rights. But I always feel like it's really important, and what she always taught me was the Bill of Rights wasn't this bundle of rights that people saw as a collective thing until years and years later. But when we think about it today, we think about the Bill of Rights as a collective group. The reason I tee that up before we dive into the Fourth Amendment is to try to help us understand the framing of what so many of those rights were about and how we understood kind of the individual and the protection the individual needed from the government. So Clark or Robert, I would love if we kind of just started with that framing of how do we see the Bill of Rights, and then we can narrow and kind of dive into the Fourth Amendment and what the role is of the Fourth Amendment in defining the relationship that people have with their government. Teed up to either one of you, and then I'll start calling on you after this, I promise.
Well, I know that Clark has had, I follow Clark on Twitter, and I know that he will make many a comment about like the number of amendments in the Bill of Rights that are about the criminal process. So rather than saying more, Clark, could you please give us your thoughts?
Yeah, thanks, Rob. I think maybe the simplest way to think of it is this: there will always be some conflict or tension between how much power the government wants to exercise and the ways in which it wants to exercise that power, and citizens' desire to be left alone, and also to ensure that they have a fair process if they are accused of doing something or if the government seeks to harm them in some way. And so about maybe a third or a half of the provisions in the Bill of Rights are substantive. They protect things like free speech, free exercise of religion, et cetera. But a very interesting and sometimes underappreciated part of the Bill of Rights that actually takes up much more space than I think a lot of people realize is about the process that the government has to follow if it accuses you of doing something wrong. If it charges you with a crime, we have a very clearly delineated and I think very enlightened procedure that the government has to go through before it can obtain a criminal conviction and punish you. Now, unfortunately, for reasons we can get into later, we've largely discarded that very painstakingly constructed process, because we allow the government to induce people to waive those rights and simply condemn themselves through guilty pleas. But on paper, anyway, the architecture of rights that's described and prescribed in our Constitution really is an incredible, I would say, step forward for enlightened and liberal government.
Yeah. And they're the product. I mean, they are all, like Clark said, they're thematically linked because they all go back to this concept of the rights of Englishmen and the idea that that you have certain rights, one being that you're supposed to be secure against invasions of your persons and property. The other one is that the government has to afford you due process and fair procedures when they go against you. And this is based off of centuries of abuses in England and in colonial America, whether it be the Star Chamber or the writs of assistance that allowed colonial officials to barge into people's homes and other private spaces whenever they wished. That was the whole purpose of the Bill of Rights, to make us secure against certain arbitrary government invasions.
And I think that framing is really important, because when we think about the Bill of Rights, we think about this list of rights that is to shield and protect the individual from government, and defining what can never be taken away from government as well, that you have this natural right to be able to be secure, to able to have thought, and to able to have friends and community around you. So I think that is so important to frame that together, and why we as modern Americans bundle these rights together, not intentionally at the beginning, but and now intentionally. Why? Because we do see this moment and this transition over our American history between when are we spelling out the Constitution to hold back the government, and when are we spelling out the Constitution to pull in the government. So I spell that out because the wave of American history timeline pulls us back and forth in this ebb and flow of rights of the collective, rights of the individual, role of the government, role of the individual. So thank you for that framing. I dropped the Fourth Amendment into the chat so everybody can read it, because I do believe, we need to be looking at these documents. We need to be looking at these words and saying, what do they mean? And how do we understand them? And why did they put them in there? So Robert, thank you for teeing us up and saying, like, there's a long history before the Bill of Rights of people being invaded by the government. So I would love for Robert, maybe you can kick off the colonial time period, and then moving into early America around some key cases that help define the Fourth Amendment and why they wanted to codify it in the Constitution, why it wasn't generally already put in the structure of the Constitution. And then Clark, maybe you can kind of pull us through the Reconstruction in the early 1920s of how that started to change in America.
Yeah. Well, let me kick it off going way, way back into 18th century, maybe even 17th century England. There's a long history in the common law. And the common law was the set of laws that the judges developed over time. And those sort of were supposed to reflect, again, those ideas of natural rights. And one of the concepts was that you're supposed to be securing your persons and property. There's a very famous case from the 1760s called Entick versus Carrington. In that case, the king was unhappy with a particular publication. And so one of his agents sent officials in to bust in and look for anything they could to show that the person had committed, I think it was either sedition, or they were being pretty salty towards the king, but the king was like, told them to bust in, find anything they can use to support a treason charge. And the court, so the person whose place this was actually sued the officers and said, you had a general warrant. You had a general warrant that said you could just go wherever you wanted in investigating this crime. You didn't have anything that was specific as to me. You didn't have anything specific as to saying like why I should be, you should be able to invade my home. And the king's bench said, you know what? You're absolutely right. It said under the common law, your right to security is inviolable. And if the government, this goes back to the idea that your home is your castle. If the government invades your security without the proper warrants, without proper pre-clearance from a judge, where they actually lay out the case against you and get specific authorization, If they don't have that, then they don't have any law on their side at all, and they're no different than a trespasser. And so in that case, the court said, if you step upon my close, if you even tread upon my soil, even bruise a blade of grass, you will be hurt. You can get sued, and you will owe, I think in that case, it was something like 35,000 pounds. It was, for the time, a very huge amount. There was similarly a similar case here in the colonies. There was these things known as the writs of assistance that also, like the general warrants, allowed, once a petty officer had one of those things in his hand, he could go anywhere he wanted in order to try and enforce the custom laws. And when those writs were getting re-upped, there was an argument against that by an individual named Otis, who said, like, these things are completely contrary to the common law. They're contrary to the idea that the officials need specific authorization to enter my home. Now, he lost that case, but John Adams is actually there at that argument. And years later, he said, this was the time and place where the revolution was born. And so the controversy over both the writs of assistance and these general warrants were a huge motivating factor for why we had a revolution and why we enacted the Fourth Amendment.
I love that line, and I think it's in the second link in there on the Constitution Center's website, and it's basically like, liberty is born at this moment. Like, this is like that we talk about, and again, why I love so much of the writing of Akhil Amar, like these big bang moments in world and global and American history, and this is like one of those big bang moments for defining how we will reinvent who we are and how we protect ourselves. I think a couple of things that you really pulled out there, and Clark, I'd love to see how this starts to change or evolve over time, is like the government has to say why, it has to say who, it has to say when and where, like really specific, and then it's spelled out in that Fourth Amendment. But also that the police or law enforcement has to get their work checked. Like, it has to get their work proven by another part of the government saying, yes, you can do this. And it isn't just the lone petty officer that is able to do and make these decisions on their own. And I think that's a very fascinating conversation when we get into modern policing and discretion and really ask and think about when is this allowed and when is it not allowed. So Clark, can you move us do we see a lot of cases in American history after the 1790s, the early 1800s, or does it kind of quiet down for a while? And then what's the next big bang moment?
Yeah, something that a lot of people don't appreciate about sort of the development of case law under the Bill of Rights is that for much of our history, the Bill of Rights did not apply against state governments. And of course, the states are the ones that do most law enforcement. The amount of police and law enforcement activity conducted by states as opposed to the federal government is orders of magnitude more. And so it really wasn't until the Supreme Court began interpreting the 14th Amendment as, quote unquote, incorporating the Bill of Rights as against the states that we first have an opportunity for the development of a body of Fourth Amendment law with respect to state activities. And up until this point, of course, the federal government had this quaint understanding of itself as being one of enumerated and therefore limited powers. And that didn't change until the early 1940s, when the Supreme Court essentially surrendered to the federal government's desire to exercise a more plenary set of powers. But that's perhaps a discussion for another day. Probably the most important early Fourth Amendment case is called Olmstead versus the United States. And perhaps not surprisingly, it arose in the context of our disastrous national experiment with alcohol prohibition. This is a 1928 case in which the government installed wiretaps on a suspected bootlegger's phones, both at his business and his home. Importantly, those wiretaps were installed not on the physical property of Mr. Olmstead, but instead they were installed in a place that was open to the public. In other words, where the phone lines entered the street. And so the question that the Supreme Court asked itself was, is this even a search given that the wiretaps were installed where the lines are physically on public property and there was no trespass or invasion onto private property. And unfortunately, the Supreme Court said, no, it's not a search, so the Fourth Amendment doesn't even apply here. That rationale was challenged by Justice Brandeis in a very powerful dissent, which the court would basically embrace about 40 years later in a case called Katz versus United States in 1967, which involved, this time it was, I believe, a guy running numbers. It was a gambling investigation, and they did a wiretap on a public payphone that the subject was known to use. And this time the Supreme Court applied a different test, which has come to be called the reasonable expectation of privacy test. And what they ask essentially is, A, does the person asserting the Fourth Amendment right to a prohibition against unreasonable searches have a subjective expectation of privacy? In other words, did they think that whatever it is they were doing would be private? And then B, is that subjective expectation of privacy one that society deems reasonable? There are some issues with that test, but it's better than what came before. And the next, I would say, probably most important case is one called Mapp v. Ohio, which was a 1961 case in which the court did two important things. First, it held that the Fourth Amendment does apply against state searches, and that the exclusionary rule applies as well. The exclusionary rule, of course, is the rule that the court crafted that requires the exclusion of evidence gathered in violation of the Fourth Amendment, the so-called fruit of the poisonous tree. And that turns out to be an extraordinarily important development in Fourth Amendment law because this gives law enforcement a very strong, or at least a stronger motivation to take seriously people's Fourth Amendment rights and be careful about violating those rights because there's at least some threat that if they don't comply with the Fourth Amendment, whatever evidence they gather will be excluded from a subsequent prosecution and may end up resulting in the defendant in that case walking free, even if they committed the crime. So I would say those are sort of the some of the highlights in terms of the development of Fourth Amendment law. Of course, there have been many cases since then, but basically the takeaway is that the court needs a framework for determining what is a search, when is a search unreasonable, and what should the remedy be. And those three cases essentially help trace the arc of the development of that basic doctrine.
Fantastic. And everybody, the first Olmsted case is the wrong one, so I just updated to the correct one. So just to catch myself there. Clark, there's two kind of areas I want to go here. So maybe we can, Robert and Clark, we can go in this direction. So one, I think the dissent around Brandeis in the Olmsted case is the one that's fascinating. It's the one that's trying to understand not just the history of the Fourth Amendment and what was currently happening, but what could be the future of the Fourth Amendment. And this is all connected around technology. So I think that really kind of springboards us into what was Brandeis kind of seeing and inferring, and others as well, not just him, about how does Fourth Amendment change and go from that castle doctrine to an individual doctrine. Like, does it protect your house? Does it protect you in public spaces? How does that really transition from some of the original conversations around it to when technology changes, when we can have far more papers and ideas and concepts on our phone than we have in our own house ever? How does that change and move us forward? But before we go there, so Robert, I'll probably kick that over to you. But before we go there, I just want to, it's perfect on the timeline, and I love a good timeline, to talk about Al Capone. So Al Capone and Prohibition is a fascinating time period. I feel like so much of legal understanding is tested during this time period. So much lawlessness happened during this time period. So much technology happened. But it's also when we put our country at odds with itself and saying, how do we grapple with laws that may not be just or fair? And then how do we see almost like a large amount of people breaking the laws that not typically would? And so typically I love to dive in all of the different people that work together during the Prohibition, leading to Prohibition and after, and then really understanding the implication of Prohibition on the Reconstruction time period, the 13th, 14th, 15th Amendment, all the way moving to the 19th. We could spend hours there. But I never want to talk about Al Capone until today. And the reason why is Al Capone's story in Philadelphia is pretty fascinating. So if you don't know it, Al Capone was actually here at Eastern State for a little under a year in 1929, almost 100 years after the first person was incarcerated here at Eastern State. Eastern State, the idea came in 1787 before the Constitution around liberty. It then was open, it was begun being built in 1822. First incarcerated person is 1829. 100 years later, Al Capone is arrested here. And the fascinating story is the story of Philadelphia, the story of, do law enforcement have the right to stop you just because of who your name is and who you are? And that's the question around this case. Al Capone had to come to Philadelphia to take a train to where he was going, and he stopped and they went to the movies. And that, him being here in Philadelphia alone, was enough reason for the police to say that they could stop him and then search him. And when in that search, they found a weapon, and that begins his stay here and his work in incarceration. Not saying that he did, he was a great guy or he wasn't breaking the law. That's not what the Fourth Amendment is about. The Fourth Amendment is about, did the police have the right to stop and frisk him in 1929? And then let's talk a little bit about that conversation. So there, guys, I teed it up for you. Dive in any direction you want, and then we'll get back to technology and the Fourth Amendment.
Oh man. Okay. So,
Fun,
all right.
right?
I'm putting on my hypo hat and thinking through all this. No, they did not have the right to stop him just because his name was Al Capone. The whole idea of the Fourth Amendment is that the whole idea of being secure in one's person, this goes back to basic common law ideas of personal security and personal liberty. I'm supposed to be able to feel comfortable that I'm not about to get jumped by a couple of cops. I'm supposed to be able to feel free to move around and go about my day. And so in this instance, it sounds like the only thing they knew about Capone was the fact that he was Al Capone. They didn't have any actual evidence of any illegality. And so that is a completely inappropriate stop and frisk. I will say it was a pretty common at the time, but it still makes it inappropriate. Even after the Supreme Court, it was almost 40 years after that, held that when you wanted to do a brief investigative detention of somebody, you still needed to have what's known as reasonable suspicion, which means some actual facts that make you suspect that the person's engaged in the crime. Again, just the fact he's Al Capone would not be enough. So it's an interesting bit of history. It's also a bit of an interesting constitutional violation.
Yeah, so the case Rob is referring to is a 1968 case called Terry v. Ohio, which gives us the sobriquet or common Fourth Amendment phrase, Terry stop. And Terry stop is one where police will stop somebody not simply to have a conversation. So the police can walk up to you and ask to have a conversation, and they do that all the time. What they don't always want you to know, but you should know, is that unless they have reasonable suspicion that you have committed a crime of some kind, and reasonable suspicion is a pretty soft standard. It's lower than probable cause, but it has to be at least some objectively articulable suspicion of wrongdoing. You can go on about your business. And that's one of the reasons you'll see people, for example, in some of these YouTube videos, they'll ask, am I being detained? That's an excellent question to ask a police officer, because if they say no, you are free to go, and you probably should. If they say yes, then it's incumbent on them to be able to articulate at that moment in time that they really had some objective suspicion about you, because if they can't, then everything that happens from then on will be subject to the exclusionary rule, as we talked about before. The other interesting thing about the Terry case, besides the standard for stopping somebody against their will, which is reasonable suspicion, as Rob mentioned, is this idea of what's called a Terry pat-down. And this turns out to be an extraordinarily important question, because sometimes police will suspect that a person is carrying something on them that they shouldn't be, and they want to see if they can find it. So the question that Terry answered is, what standard do police have to meet in order to pat you down? In other words, to feel what object they might be able to discern underneath your clothing. And if they suspect it's a weapon, as in the Al Capone case, they have to have an objective belief that not only are you armed, but that you are also dangerous. And those actually turn out to be two discrete inquiries. First, is there a reasonable suspicion that you're armed? And if so, is there a reasonable suspicion that you're dangerous? Now, up until relatively recently, police would tend to just collapse those into one. If you were armed, you were therefore presumed to be dangerous. But with the advent of modern Second Amendment law, where now throughout the entire country, there is a right to carry a firearm subject only to objective and relatively low levels of permitting requirements, it is not. If it was ever reasonable for police to assume that anybody they encountered who was carrying a gun must necessarily be dangerous, it's no longer the case now because millions of law-abiding citizens carry guns lawfully every day. And so the courts are still trying to work out what additional factors would police have to show to meet the Terry standard of not only suspecting that you're armed, but also having a reasonable suspicion that you are, in fact, uniquely or specifically dangerous before they can put their hands on you and do that pat down to see what you're carrying. And we've seen courts kind of all over the map on this. So this is a very interesting area of Fourth Amendment law that is not really shaken out yet. With the advent of this intervening Second Amendment case law that really reset the table in terms of what's reasonable for police to be suspicious of when they encounter people on the street.
So that's the exact second question around that. Are we looking at any current cases that are coming through the courts towards the Supreme Court on this? Because I really appreciate how you're both kind of breaking down what's the founding framing idea around secure in your persons, your places, your belongings? And then breaking it down again, I feel like we need a tree diagram here around search and seizure, because they're searching somebody, but it's also stopping you, and that's seizing your person and making you not move forward. So breaking down again, and then Clark, thank you for that again, then breaking them down even further to say that you have to be both armed and dangerous. So are we looking at any current cases that you keep a watch on that are moving through the courts? And this is really for either of you.
I have not seen anything on that front, but maybe Clark has.
There are several cases that the circuit courts, that's the intermediate federal appellate courts, have decided that have gone different ways on sort of what quantum of evidence do police have to have before they can consider you to be dangerous. I don't believe any of those are currently sort of pending in a cert petition. That's the document that you file with the Supreme Court asking them to review a lower court decision. But one area that is somewhat related that Rob and I are both following very closely and is absolutely fascinating, and again is somewhat adjacent to this, is the implications of law enforcement using technological means that did not exist at the time of the founding. And I'm sure we could both give you any number of examples, but one that I find absolutely fascinating is when police use vehicles that didn't exist at the founding. So for example, can they fly an airplane over your house, look down into your backyard and see that you maybe are growing some plants that you're not supposed to be growing? I think we all know what those plants are. In a 1986 case called United States versus Serrallo, the Supreme Court held that that is not a search because you've got planes flying over your house all the time, and this one just happened to belong to the police. You can probably tell from the way I'm inflecting that I don't agree with the decision. But then they took it another notch higher a few years later because at least in that case, it was a plane that was up, I think it was a couple thousand feet up in the air. But the next case was called Riley, Florida versus Riley in 1989. This was a helicopter that was just 400 feet off the ground. And I'm here to tell you, anybody who's ever had a home with a pool and kids, and perhaps teenage kids in particular, you don't expect anybody to be flying 400 feet above your house looking into your backyard. And you'd be pretty offended if they did, whether they worked for law enforcement or not. But once again, the Supreme Court said, not a search. And then I'll hand it off to Rob, because now where it gets really interesting, right? Most of us don't have a helicopter parked outside our house, I'm guessing, or in your garage. But you know what lots of people have these days? Drones. So Rob, take it from there.
All right. Well, thank
Oh,
you, Clark.
good topic for Philadelphia too.
Yeah, we actually had a case just recently, about a year and a half ago, 2 years ago, at the Michigan Supreme Court. A township there was using a drone. It wanted to basically show that somebody was violating zoning rules, and so they on their own, the zoning officials went and hired a drone operator and flew that drone all over the guy's property, like 3 times over a couple of years, like really detailed images. And the whole issue was, is that a search? Is that a search? And we asked the Michigan Supreme Court to say whether that was a search, and they ducked it. And they ducked it for the reason they said, even if this is a search, we don't need to get into that, because even if this is a search, the exclusionary rule doesn't apply here. And so even if this is a search, we're not going to say that they can't use those photos in the zoning controversy. And so we're not going to decide this. So it's maddeningly still, it's a completely open question in Fourth Amendment law whether the government can fly a drone over your property in order to gather information about you. Some courts have said they can't. Other courts have ducked the question, or they've said that there is no search because you have, again, this idea of no reasonable expectation of privacy. And I know we're going to do Q&A in just a minute here, but I do want to say this. I hate the reasonable expectation of privacy test. I hate that test just as much in different ways than I did as the trespass test that came before it. The trespass test is what you just heard Clark talk about with that Olmstead case. And they said, since you didn't physically trespass into the guy's home, no search. The problem with the reasonable expectation of privacy test, it gets rid of that like physical intrusion requirement, which is good. But then it creates this incredibly malleable circular idea that the only thing that you have that is protected is the things you have a reasonable expectation of privacy in. Where in the world does this word privacy come from? I know Brandeis said it in his Harvard Law Review article and then in the dissent to Olmstead, but the text of the Fourth Amendment doesn't mention anything about privacy. It mentions that we have the right to be secure against arbitrary government invasions of our person and property. And the biggest problem from my point of view about the reasonable expectation of privacy test is it sets up a false metric. It says anything that you hold that in order to maintain your Fourth Amendment protections, you have to secrete something. You have to keep it private. You have to hold it back. And almost instantly, within just a few years of cats coming into play, we started to see cases creating what's known as the third party doctrine, saying that your phone, the numbers of the phone numbers you call aren't protected, your bank records aren't protected. It's even gotten to the point where the government can have a camera trained on your house for 6 months on end. And courts are saying that's not a search because because after all, how could you have privacy in the exterior of your home? I'm dealing with another issue where there's these things called flock cameras that keep a comprehensive log, a database of every car that passes through them. And right now, we're suing Norfolk, Virginia about it, and they're saying that's not a search. We can track every single vehicle that comes through the city of Norfolk. We can log them. We can keep a comprehensive chronicle of their movements for 30 days, and there's nothing the Fourth Amendment says about that. And to me, that's just the most damning indictment of this idea of privacy being the metric as opposed to security against the government.
And thank you for framing that too, because so often we talk about these like values that people have and they gather around. But when we look at the documents, we don't see those words. And we have to almost like parse out over time, where did these ideas come from? And are we framing those as norms? Or are we actually codifying them in the law and saying where do they're opinionated? It can be subjective. It can be very tricky. We jokingly said like the one word that's missing from the Constitution that everybody talks about when they talk about the Constitution is freedom. So we talk about it all the time, but it's actually not in the Constitution spelled out directly. So it's very important because people talk about privacy all the time, but then when you look at their words, kids, students, when we work with them are like, well, where is it? And that is a different concept around norms and values and how do we spell it out? And when should we spell it out? And when should we really say, no, the words are there, you just need to reframe which word you're utilizing? So let's dive into that kind of third-party doctrine and technology and around cell phones, which one of our educators, Dina, brought up in the chat. I really want to unpack that a little too, because where did 30 days come from? Kind of help us understand all these pieces and how they come together. And then I definitely have a couple of DNA questions on third parties as well.
Well, with the
I'll jump in really quick with cell phones and hand it back to Rob. The most important thing I think you can understand about your cell phone is to imagine it as, imagine your cell phone as a kind of a metaphorical lawn sprinkler, just spraying your personal information out into the atmosphere in huge volume and constantly. Now, the good news is that most people don't have neither the means nor the motive to intercept that data, to make any use of it. It's just out there, and ordinary people wouldn't be able to access it and don't have any reason to do so. But you know who has a motive to do so and the technical means? The government. And so the government is out there hoovering up vast amounts of information that are being thrown off by people's cell phones. And really, in some ways, we're still in the infancy of Fourth Amendment doctrine in this area, and there are so many different issues that come into play. To take just a few of them, one question is, what steps can the government take to track your physical movements? As you probably know, your cell phone is constantly reaching out to different cell phone towers as you go about your day, travel around. If somebody has access to that data, they're going to be able to reconstruct with pretty significant detail where you were and when you were there. There's also, of course, the question of when the police want to question you, can they search your cell phone? Can they force you to unlock it if you have, a lock on it, a code? Can they search the cell phone, for example, to look for evidence of a crime? That led to a very interesting case in which a lot of people predicted the Supreme Court would get it wrong. This case also is called Riley, don't be confused. But this was a question about whether the police have to have a warrant to search your phone incident to an arrest. When the police arrest you, they have a limited ability to conduct certain warrantless searches, including of your person to make sure that you're not carrying weapons, and to some extent to containers that you might have control over. One of them being a wallet. The Supreme Court held that the police could search your wallet without a warrant incident to arrest. Well, the law enforcement tried to analogize people's cell phones to a wallet and say, oh, this is just the modern day equivalent of a wallet. To its immense credit, the Supreme Court unanimously rejected that argument and said, no, 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 no. A cell phone, a smartphone is nothing like a wallet. This is your entire life in some ways here. So it does require a warrant. But there are, I'll stop there, but there are any number of other things that police can do, including not just, sort of old-fashioned wiretaps to actually listen what you're saying to people back and forth. That's in some ways the easiest one. They still have to get a warrant for that, and the standards are reasonably high. But there are all kinds of other things that the police can do, including, and I'll just add one more example, this ominously named Stingray. If you've never heard of this, this is a very sinister program that the government can use to spoof your phone into connecting with a government-operated decoy cell tower, because when your phone hooks up with a cell tower, it immediately starts dumping vast amounts of information, metadata, location data, other things. And the government has developed a program called the Stingray program where it can just go out in public, spoof people's cell phones into connecting with a government pseudo cell tower and access that information. And they've been extremely reluctant to give up information about how this works or to acknowledge that there are any sort of legal restrictions on their ability to use this technology to acquire people's sensitive information. So all of that is continuing to be worked out in court. But I'll end where I began, which is this. You ought to think about your cell phone as a device that is constantly spewing vast amounts of information about you into the public sphere. Generally speaking, that's not a huge problem because most people don't have the means or the motive to intercept and make sense of that information, but it's extremely significant that the government does. Granted, they're probably not just going to pick you out at random to start culling through that information, but if they suspect you of something, you'd be shocked at how much information the government can get just by homing in on the information that your cell phone is passively putting out there.
Robert, do you want to share anything on that? And I have two final questions for y'all.
Well, it's interesting. The Riley case that Clark just mentioned, that's actually it's where the court. Now, usually I said like the common law gave us our right, was the basis of our right to be secure. And the common law said that when you arrest somebody, you could search them. So that was the common law rule, and like Clark said, I think the court recognized that the just the nature of the items we hold, i.e., a cell phone, is just so much more invasive to allow the government to sort of arbitrarily get its hooks into, to be able to look into, that's a place they said, even if the common law said that this was okay, due to technological changes, we're going to say, no, you need to get a real warrant. So that was a major advance. And the court is trying to deal with technological changes. You can see that in the Riley case we just talked about. Carpenter, which is a 2017 or 2018 case about cell site location information. That's the information your phone hands off when it connects to a tower, a real tower, not a police fake tower. So they're trying to handle these things, but the problem, at least from my point of view, is that the test that they have is just not up to the task. It's too subjective. It doesn't allow for any kind of principled line drawing. Like in Riley, they said, well, usually we allow this, but this is special, but without a clear articulation of why is this special. And I think that's a bigger problem with Fourth Amendment doctrine. I think a lot of the problems we have in the doctrine right now, a lot of the things we see are the result of the fact that no one's really thought deeply about how to interpret and apply the Fourth Amendment. And so we sort of veered from one approach with the trespass test to another one with the reasonable expectation of privacy test, but neither really has adequately protected our right to be secure.
And thank you, because that really helps kind of tease out something that Karen shared, and around some of the DNA cases too, is, how do we really frame this to make sure that dangerous people are being caught, are being convicted? I think it's the Golden State case is the one I'm thinking of right now around the DNA and using third-party data from police, being very thoughtful about how do we catch a violent criminal that is killing people, but doing it in a way where there's a legitimate government test to measure it. And bottom line, and I feel like I can quote Clark saying this over and over and over again, get a warrant. Just get a warrant, do your homework, do your work. So as people are thinking about how to keep people safe, but also keep people protected, how would you really kind of frame that balance? And it shouldn't be a tension, and it shouldn't be at odds with each other, but it's a duality. We can hold these two things together at the same time, safety and security.
Yeah. From my perspective, I'd say the Fourth Amendment is that balance. I mean, the whole point of fighting a revolution and reducing these ancient rights to paper was that this is the bargain we've struck as free citizens who have entered the society. We're saying that if you want to search us, if you want to invade our persons or property, go to a judge, get specific authorization. You can't do this on your own. So that to me is like the hallmark of the Fourth Amendment. So
one of my biggest concerns is the court's failure, I think, to appreciate how times have changed with respect to criminal law, and specifically our tendency to criminalize vast amounts of totally harmless conduct that doesn't threaten anybody. Just take one example. The possession of a bag of marijuana is not going to hurt anybody any more than a possession of a six-pack is going to. But what happens when you criminalize that kind of activity is that you open up opportunities for the government to use these very powerful investigative techniques to violate people's privacy or to impair their privacy in ways that we might be willing to put up with if they were literally trying to catch a serial killer or solve a kidnapping. But when it comes to, oh my God, does that person possess the wrong kind of plant? And I mean that in a serious way, because think about it this way. If we only criminalize genuinely harmful activities and conduct, things that really represent harm to other people, very few of us would have any reason to be concerned, because very few of us engage in conduct that would ever harm another person because we're good, moral people. But we don't stop there. We criminalize all kinds of conduct that is not morally wrongful and doesn't threaten the fabric of civil society anyway. Everything from drug consumption to gambling to other victimless crimes. And so, if you happen to be a person who sometimes engages in some of this illegal but non-morally wrongful conduct, and guess what? That's most of us. Then you are absolutely at risk of having your privacy rights, your right to be secure in your person's papers in effect, interfered with by a government that no longer confines itself to criminalizing activity that genuinely threatens other people or the very fabric of civil society, and criminalizes a vast range of totally innocent in the moral sense, conduct. So the stakes here, I think, have gotten much larger than they were at the founding era because there were so few crimes back then, and they were by and large about very serious things that most people would never be involved with. Now that's completely flipped around. We criminalize vast amounts of conduct, and most of us, by the time you get to be an adult, have committed one criminal infraction or another. And so really, most of us are at risk from having our lives interfered with by the police. And so in some ways, the stakes for getting the Fourth Amendment right have really increased. At the same time that, unfortunately, I think the Supreme Court in some ways has grown less protective of the values that are encapsulated in the Fourth Amendment. And I think it's a very tenuous place for us to be as a society.
That frame. Oh, sorry, Robert. Do you want to chime in?
I was just going to note that the most violence that has been done to the Fourth Amendment has occurred in response to prohibitions, whether the prohibition against alcohol in the 1920s or the prohibition on other illegal drugs in the 70s and 80s. That there's any number of cases that weaken Fourth Amendment protections have their roots in those two periods.
And it's such a perfect connection back to Eastern State, too, because we have a Prisons Today exhibit. And the first thing you do is you walk in and you answer a question: have you broken the law? And sometimes when I'm trying to think through and going down like intellectual rabbit holes on like Fourth Amendment and criminal justice reform, I watch how people react to that. And it is very hard for me sometimes when I see an adult say no, this is not say, liar, like you probably have, like, it is really easy to do these things. And like, how do we analyze that? And that is like framing around that. Are we setting up a structure that is fair and just when so many of us are going in one direction over the other? So last kind of wrap up question is from Jordan. As you pointed out, the Fourth Amendment protects they can help protect lay citizens from homegrown. How do you protect lay citizens from homegrown videos? Oh, it went away. Hold on, let me try that again. Homegrown citizens from regular citizens from homegrown videos that are posted on the web. How does the average citizen keep up with new cases in defining new applications and protections under the Fourth Amendment, other than relying on social media? And is there recognized opportunity to objectively educate our citizens? So I'm going to drop in, Robert, your project on the Fourth Amendment, and Clark, your project with the Sphere Institute on the Fourth Amendment as well, and criminal law. But I'd love for you to real quick give some sources and sites for places people can go to be active, because a part of our mission here at Eastern State is to ensure that everybody recognizes the responsibility that they have in doing this work and holding our government accountable. So to you both.
Yes.
Well, let me just quickly dispense with the question. I don't mean dispense with it, but respond to it really quickly. To the extent I think Rob and I can understand it, the most important thing I think to understand is that the Fourth Amendment, as other provisions of the Bill of Rights, only restricts the power of government. And that's a good thing, actually. Keep in mind, if somebody comes to your house for a dinner party and starts engaging in very offensive conversation or jokes or something like that, it's very important for you to have the ability to tell that person to leave. And you can. You don't violate somebody's First Amendment right of free speech by telling them to stop telling racist jokes at your dinner table or else leave your house. That's a private interaction. It's a private association to which the First Amendment doesn't apply. Same thing when it comes to posting videos online. There may be other legal ramifications of posting videos. There is a tort, meaning a private right of action, for the disclosure of embarrassing facts. So you could sue somebody. And this is sometimes falls under the rubric of so-called revenge porn. Let's not go further than that, but we'll just say it's not the case that the law leaves people without remedies simply because the Fourth Amendment doesn't apply to that particular conduct. But it's a different legal regime, and one that we'll put a pin in for now. But Rob, you've got the Fourth Amendment project, so why don't you take us home?
Well, I mean, I think you said it exactly right. The Fourth Amendment is against the government because the government, and remember this, the government is special in the sense that it's special. Nobody else can arrest me. Nobody else can throw me in Eastern State. Nobody else can, legally, there are just unique powers that the government has that no one else possesses. So I get the idea that I might not like somebody putting out a video of me that's might be embarrassing. And as Clark mentioned, there are avenues, but no private individual has the awesome powers that the government have to restrict my life and liberty. And so that's why the Fourth Amendment is so critical. And yeah, there's lots of areas where legislation can fill gaps, like Clark mentioned. And again, I know I'm a hobby horse on this. This is why that idea of privacy is so pernicious. Because when Brandeis talked about privacy, he originally wrote about like the idea of like being able to keep reporters from reporting about you or photographers from taking your photo. He's talking about private conduct. And again, like when you focus on just the idea of being private from the entire world, that means the only thing you can do is sort of turn into a hermit. But that's not what the Fourth Amendment, that's not what the framers wanted for us for the Fourth Amendment. They want us to be secure against the government.
So I see the questioner clarified, saying the real question was how do we educate people about this without sort of resorting to social media. As the parent of two children, I'm not sure it's possible to educate the next generation about anything without relying on social media. So I'm not sure what the answer to that question is. I'm being a little bit flippant, but I think the short answer is we live in an era, of course, where we are all confronted with an absolutely, a tsunami of information every day. And so the challenge, I think, is trying to capture people's attention and persuade them that certain things are really worth devoting their attention to when they have so many competing demands on their time, their attention, their desire for entertainment. And I think it's incumbent on all of us who care about these issues to figure out a way to make them relatable and engaging. And I like to, and Rob, of course, we both started off at the same place, the Institute for Justice, where it's really drilled into us that when you can, you try to tell a story, try to make it relatable, and make it human, right? So use examples. This is what happened to an actual person who you might be able to imagine yourself being in the shoes of that person. And here's what's at stake if we don't get this right, for all of us, not just that person, but also for you and everybody that you care about. But again, I think those the real touchstones here are keep it relatively simple, make it relatable, make it engaging so that people are emotionally connected with the information. And, hopefully it won't take a firsthand encounter with law enforcement before people realize how incredibly important it is to get these issues right, including your right to be free from unreasonable searches and seizures under the Fourth Amendment.
Yeah, I don't know if it's social media, but I will plug, we have a number of videos on YouTube that we do for our cases, and I think they are really good examples of what Clark is mentioning. We try to boil down concepts into something that's relatable. There's a human face, and they explain like why they don't want this for themselves or for anyone else.
And you both have modeled that so well today. So I want to thank you so much for telling these fascinating stories, making it relevant. And I think that's the thing about social media is and we saw this in the last election, if people start with the issues that they see in social media or they see in their lives, start where they are and bring it back to that framing, that founding, and that understanding of how the system works and what questions we have on the system. As an educator, you always start with your student. Like, what do you care about? What do you want to know? But you two did such a wonderful job really helping us all say, what are the issues that we're seeing? How do we frame it in questions? Can they do that? Which is my number one favorite Fourth Amendment question when talking about the government, talking about search and seizure. Like, can they do that? Really great founding questions. And that was, You know, that came from high school students. That was their number one question when they were watching what was going on social media. And then you can back into the Constitution. So I want to thank you both so much. And for everybody who's been listening, we will do a roundup with all these great resources, the last two I just shared, and the videos as well on the YouTube channel. So thank you, Clark. Thank you, Robert. This was a fantastic way to tee up Bill of Rights Day. So thank you and have a great day.
Our pleasure.